Good morning. It's 9:32 a.m. and I like to call today's hearing to order. There's one hearing on the docket. It's a hearing number 6274-1. Two of us are participating remotely. Ms. Verdugo Peralta, I presume your location was posted pursuant to the Brown Act,
Yes, it was.
and you're in the location alone?
Just with Mr. Peralta.
And we love Mr. Peralta. We love him immensely. And I too am remoting in to the hearing from a location that was posted pursuant to the Brown Act, the old Brown Act, and there's no one in the room with me at all. I just want to be very clear. All right. Are there any exhibits? I didn't see any exhibits. There are no exhibits.
Yes, and we sent you an email about 5 minutes ago.
Okay, we'd like to mark those exhibits. So, and what exhibits do we have? Can you turn your microphone on?
It is a proposed variance conditions from the district.
And that's exhibit number
A.
That's A. Are there any exhibits from the petitioner?
None.
Okay. All right. And so, petitioner, just to be very clear, you have no exhibits, correct?
Correct. Just the petition and the attachments of the petition.
Okay, very well. And I presume, one second, Madam Clerk, are there any individuals online or in person desirous of providing non-evidentiary testimony and or general public comment or evidentiary testimony?
None.
Okay, the record is clear that no one has sought recognition to provide public comment and or evidentiary testimony. All right, we're gonna.
Mr. Chair, we do have actually a couple of people under public comments that want to provide comments.
Oh, that's okay.
Okay, we'll go ahead and we'll tee them up. How many individuals do we have?
It's not related to this case. It's under just public comments that they want to provide.
Okay, so let's go and take general public comment.
Okay.
Three minutes on the clock.
Take it afterwards.
Two. I'll make them wait.
Sir,
morning.
can you state your name for the record? 3 minutes on the clock.
Yes, my name is Ryan Baldino. I'm the Mayor Pro Temp of El Segundo, California, and I'm here today to express our community's feeling of abandonment that the abatement order on Hyperion was allowed to expire on August 5th without a public hearing. Your last meeting in November, you showed courage and you extended the abatement order another 6 months because there were still problems at Hyperion. I'm here to remind you those problems exist today. Since the November hearing, there have been 341 odor complaints from Hyperion. That has resulted in 12 NOVs. Need I remind you, the accident that happened in July of 2021 was not just an environmental catastrophe. It has caused an ongoing public health crisis of the air that we breathe at a facility that we no longer can trust. The problem still persists. Los Angeles has not helped us. They have made promises of systematic change. They have made promises of hiring a new plant manager. They have failed to deliver on those promises. The same people who worked there during the accident are still employed at Hyperion. Our residents want answers. When families in El Segundo have to leave our community and move out of the city because they don't know what they're breathing, that's a problem. For a long time, this board was the only advocate we had, and Inspector Haynes was our champion. And then he disappeared. And then he no longer gave testimony to this board. And what we heard were some platitudes. We've hired Heal the Bay at Hyperion. We're an environmental champion. We are being greenwashed right before our eyes. Things have not changed there. And now we've got no one to turn to. We are left on our own in El Segundo when it comes to air quality. Thankfully, we've got a state law keeping fence line monitoring intact in perpetuity. Thankfully, our legislators stepped up and helped us do something about the Los Angeles Metropolitan Sewage Treatment Plant, which is still to this day not being run properly. And so again, I'm just here to say after years of hearings, we are still left with questions out there. And at this point, I don't know what, if anything, AQMD can do, except I guess I'll see you after the next disaster that happens. Thank you for your time and your energy that you put into this. And I just wish you would have responded to our July letter asking for a hearing date before the August expiration date, so that we could at least explain to the public why it is we think Hyperion's doing a good job. But we never had that opportunity. And so that's why I drove out here today, just to give public comment. Thank you for your time.
Thank you. Thank you very kindly, Madam Clerk. Any additional speakers for general public comment?
Good morning. My name is Daniel Pankow. I'm the Environmental Programs Manager for the City of El Segundo. We are disappointed that Abatement Order 1212-40 between the South Coast Air Quality Management District and the Hyperion Facility, City of Los Angeles, expired without the matter being agendized before this board, despite our numerous requests. While we are copied on the monthly progress reports from Hyperion to the AQMD, these reports are difficult to interpret and hard to follow since they don't seem to be in chronological order. We do not know if all the conditions have been completed and how to relay or explain these findings to our residents. Since the last abatement order modification hearing on November 19th, 2024, there have been 12 notices of violation and 341 logged odor complaints. We would like to confirm the compliance status of the conditions listed within the abatement order. The continued AQMD oversight is critical to the ongoing health and safety of our community and the regulatory and environmental compliance of the facility. Thank you very much.
Thank you. Are there any additional speakers, Madam Clerk?
None. That is it.
All right. Thank you very kindly. Okay, we're going to administer the oath for the witnesses. How many witnesses do we have present? So why don't all the witnesses stand? Mr. Jones, you representing the district. You have any witnesses?
Yes, we have two members of staff who are available for questions, but
Right. And who's representing the respondent?
I am Timothy McElfish, and I have here today Jose Vasquez and then William from Montrose.
Okay, good deal. So we're going to administer the oath. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
All right, let the record reflect that all have accepted the witness oath. Ms. Verdugo-Peralta, is your question specific to this case or any other case?
It's in response to the two speakers. It's
Yes,
not.
and no one
question.
is present. No one is present to answer those questions. And so the district's attorney, Mr. Jones, is not in position to answer those questions. He's here for this particular case is before us.
I understand that, but I just had a general, I guess, comment
But no,
And-
but we don't want to
Can we do
comment
that
on
at the
public
end?
commenters. No, you can do it at the end,
Yeah.
but not, the public
can-
has a right to
that's fine.
redress the board. And then, of course, if you want to comment, we can do that toward the end.
Okay, that's fine.
All right, good deal. All right. Petitioners, the petitioner, your case, please open up for us and let's proceed forward.
Morning, Chairman and members of the board. Thank you for taking the time to have this hearing. For the reasons set forth in the interim and general petition, we submit that the facts support granting the interim variance petition. We submit to the board that the facts and the conclusions support the findings that are in compliance with Health and Safety Code 42352 necessitate the granting of this interim variance petition. As to the bifurcated issue of good cause, we submit the following. The board has 4 factors that it looks at, and we believe that the petition and the oral arguments today are going to support, and Jose's testimony is going to support a finding of good cause. The first factor is the petition is in violation of Health and Safety Code 41701. On July 15th, 2025, the results showed that the permit conditions for the petitioner were not in compliance. Specifically, permit numbers G70103, device number 44, and permit number G70105, device number 45, both being the noodle fryers used in the production of the Marishon products. The noodle fryers are a necessity in order for it to produce the products. And we affirm that as a result, the petitioner submits that they are not in compliance with that they're in violation of Health and Safety Code 41701. The second requirement is the circumstances leading to the violation could not reasonably have been avoided by a petitioner or anticipated. We submit that, just as I mentioned, that the July 15th, 2025 results were recently learned by petitioner. And as described in the petition, petitioner took immediate action concerning consulting with the environmental expert and proceeding with this interim variance petition and the variance petition. They learned of the requirements that were necessitating completing and submitting the documents and the information necessitating the results and the background of why this interim variance should be granted. As I'll discuss later, there's a huge economic impact to Marishon, not only to the business, there's also an economic impact to each one of its employees that would be displaced as a result of this. There's no known adjustments or changes to the production lines used in the noodle fryers that could have avoided the current situation with the petitioner being out of compliance. And as a result, a shutdown should not occur of its production lines, which is why they took direct and immediate action in filing this interim variance and the general variance petition. The third factor is that petitioner exercised diligence in petitioning for an interim variance petition and scheduling this hearing. And that essentially means that the petitioner filed the petition as soon as feasibly after the time petitioner knew or should have known that the variance would be required, more likely than not. We submit that at the time of receiving the July 15th results, that is when Marishon would have knowledge that this petition process was necessitated. They were informed by their environmental consultants at the time of getting these confirming results. And this was the first time that the Deer plant, where the fryers are, since 1978, have ever had an issue with the results. Marishon has never been before the AQMD board. And this is the first instance that we submit this type of a variance. Again, we submit to the board that learning of the July 15th, 2025 results, petitioner reasonably learned that more likely than not that they needed to proceed with interim variance. To that end, petitioners immediately began working with the consultants, working with management in order to compile the necessary information to set forth in the petition to allow for this board to grant this interim variance. The fourth factor is that a denial of the interim variance will result in an increase of emissions, air pollutions, and an adverse impact air quality and/or an adverse impact on public health or an unreasonable and unavoidable adverse impact on petitioner. As set forth in the petition, the daily economic impact to Marishon and the petitioner would be substantial, not only for the workforce that they employ, but also the training that they have invested in these employees. And as a result, there would be a huge monetary impact to petitioner. Impact to petitioner would be a cascading effect, not only on the products that Marishon produces to the general public, because there's no other reasonable means for Marishon to shift production to any other locations or facilities, because the deer plant in these lines specifically produce specific products that are only produced at this plant on these lines. For the aforementioned reasons, petitioner submits that good cause exists in granting this interim variance petition. Petitioner duly notified AQMD by this filing of the instant petition in a diligent manner, is working with the prosecutor. As Exhibit A, we've come up with and agreed to some proposed variance conditions that would be implemented today and would result in actual reporting requirements starting today and being reported to AQMD next Tuesday. And also there'd be additional reporting requirements on a monthly basis that will be beginning on September 9th. All of these actions will be taken before the actual general hearing petition. So understanding that this is a bifurcated hearing, first as good cause, I'll submit, this oral arguments at this point, and I'll let the prosecutor.
Okay, Mr. Attorney for the petitioner, would you please spell your full name for the record?
First name Timothy, Timothy, McElfish, McElfish. Thank
you, and you're 100% correct. This is a bifurcated process, and we are establishing good cause prior to moving forward. Thank you very kindly, sir, for your opening remarks. Mr. Jones.
McElfish, McElfish.
Okay, we're good? Good. All right, Mr. Jones, the floor is yours.
Right, you're able to hear me? Oh, good. John Jones on behalf of the executive officer. We, having looked at the underlying circumstances, we'll agree that they were certainly diligent. We've been negotiating over the past several days about the proposed conditions that were submitted for your review today, which can be used as the basis. So we think under the circumstances is something they control. They contacted us, we've been working with them, they've been extremely cooperative. And so if the board were to find good cause, the executive officer would not oppose that.
Thank you very kindly. Mr. McElfish, is your first witness.
The first witness that I'd like to call is Jose Vasquez, who, and he's available here for questions that the board may have. I'll provide some background for him. If you can tell for the record, say your name and spell your name.
First name is Jose, last name is Velasquez, V as in Victor, E-L-A, Z as in Zebra, Q-U-E-Z. J-O-S-E. I'm the Senior Operations Manager for Marishon Inc.
And just for background, are you familiar with the petition?
Yes, I am.
And to your knowledge, has Marishon ever had to file an interim variance or a general variance?
No.
And how long have you worked for Marishon?
13 years.
I would submit if the board has questions for Mr. Vasquez as related to this good cause, he can testify and provide background information, but I think the petition sets forth the basis for the good cause.
Okay. Mr. Jones, did you want to cross?
No cross from the district.
Members of the hearing board, Ms. Verdugo Peralta, see your hand is up.
Thank you, Mr. Chair. Mr. Velasquez, I wanted to know whether you were the one who was one of the participants, or did you respond to the district yourself, or was that another party?
We use a consulting service, Montrose. There are our environmental consultants.
Yes, we're familiar with them.
And on our behalf, they were communicating with AQMD and reporting all necessary data or information, or providing documentation as well.
The only question that I have is not that I do not find good cause. I do find good cause in reference to all of the information as well as the conditions. My only question is in regards to the petition. I believe it's item number 15, where it asks for a separate document that is a timeline. And I have not received one. Did you send one into the AQMD? Because that is supposed to be part of the package when you do send it in. And it's just it's a question of the timeline that gives the board a better snapshot of exactly what happened. And that's the whole purpose of turning in a actual timeline.
We did not submit it because we thought that the petition set forth the dates clearly.
Well, that's why it says in the petition, and it should be on a separate document. And I understand, that you can take that as you on 15, that may have been how you responded, but in the future, and I know we'll see Montrose in the future, I would suggest that you include a separate document, just as requests, with a timeline so that we can have a better snapshot of exactly what happened. That's all. Thank you.
Understood.
Thank you.
Understood. Thank you.
Any additional questions from members of the hearing board?
Yeah, Mr. Chair, I do have a
Yes,
follow-up
floor
question.
is yours.
So, Mr. July 2025 was not the first time you knew there was an issue with the fryer, right? I mean, I'm following up on the timeline, basically. According to the petition, you knew there was a problem as early as December 2024.
That's correct.
And then you got the results. But why didn't you file at that time when you knew you didn't meet the emission limits for a variance?
So when we tested in December, it took quite some time to get the results. If I recall correctly, one of the test results, I guess we can obtain sooner than the other because of the lab. We scheduled to retest and looked at our equipment. And for us, was big surprise. We've never had this issue before. So we were trying to take the steps to whatever was wrong to rectify it, because no other conditions within our production equipment or cooking equipment has ever changed. It's been the same since the 70s. That portion of our manufacturing facility. And to my knowledge, by the time we got the results, we had already scheduled for another test, which we had in April. So there was maybe a few weeks in between getting the results and having the new test be conducted.
Petition also said you applied for a control system while mist separator in 2022 and you got the permit. So was that in anticipation of problems with the fryer that you wanted to install the control system?
I have to look at my notes how it came about. My understanding is that at one point we were going to ask to resubmit it and another permit for different conditions. And based on the consultants we had at the time, they told us that if we wanted to do that, more than likely we will need a mist control system to control emissions for those two lines.
Okay. So that's why you applied to install mist control.
Correct.
And it's pending still. Correct. With the permitting, according to the petition, it's been held up at the city of
Yes,
Irvine.
sir.
No, I'm just trying to find out whether you've been diligent filing when you found out. So you retested in July, you found out that you didn't pass, so that's when you initiated. Now, do you normally have to check with back the headquarters before you can do anything? As like in this case of filing a petition, it seems like there was a little bit of delay. I'm not saying it was inordinate or delay, but a couple 2 weeks, but still, I was kind of surprised to go back to corporate to do the filing for a variance.
There were basically just discussions as to how we were going to go about it, what we were willing to do. We were more, to be quite honest, concentrated on fixing the issue or understanding what went wrong in the process of doing the filing for the variance. So that was part of the delay as well.
And also, if I may just ask one question, follow up on that.
Can I finish? And then
Oh, yes, absolutely. Sorry.
You know,
yes, absolutely.
And again, on the petition, you were going to do another retest. Did you do that retest? According to the petition, there was sometime after the July test, you were going to do another retest.
Yes.
With a lower production rate.
Yes.
Yes.
And you got the results of the retest?
We got partial results of the retest.
Still showing non-compliance?
No, actually showing compliance on one line, and we're waiting for the results for the other line.
And that's with the reduced production rate?
Correct.
Okay. All right. Thank you. I have no further questions.
Mr. Jones, the floor is yours, my friend. Cross.
Oh, sorry. No cross from the district.
Okay. All right, your next witness, sir.
Did you want to follow up? Was there a question?
Well, I was just follow up on one question, just with his point was more as to the requirements of having to go back to Japan in order to actually seek this and seek authorization. Yes. Yeah, that's part of essentially the process, correct? That it has to go back to Japan to approve this type of process. Because conceivably, this was the first time, correct, since 1978 that any of this certainly had happened. There had to be a report back to main corporate headquarters.
That is correct.
Yeah. Okay.
Thank you, Ms. Verdugo-Peralta. Did you have another question? Oh, your hand was up. Okay. Okay, sir, did you have any other witnesses on your side?
Just from Mr. Winchester from Montrose, if the board has any questions in regards to the results.
My name is Bill Winchester. I'm with Montrose Environmental Solutions. My name is BILLWINCHESTER. I am a principal scientist.
Go right ahead, sir. Were there any questions of the board?
I have just a few questions. Just have you reviewed the petition? Were you assisting in the drafting this petition?
Yes, that's correct.
And then after July 15th results, you consulted with Parrish in regards to filing this interim variance petition and general petition?
That's correct. When we discovered the test results were confirmed, we got the test report from the test company. We informed Maruchan that this would be an appropriate action to take given the test result.
Thank you.
Mr. Jones.
Regards to the results.
I'm sorry, Counselor, on the petitioner side, were you still asking a question? Because there's a bit of a delay.
No,
Okay,
I'm just
Mr.
going to
Jones.
offer up.
No, no,
Okay.
district.
Okay, members of the hearing board, any questions?
Yes, Mr. Chair.
Mr. Balakapalan.
Just, somebody was contacted by to start the paperwork for the variance,
It was when we found out about the test result on July 15th.
July 15th, but you've been working with them prior to that.
For other matters, not necessarily related to source testing. It was just that was the date that the source test result came back. And given the findings, that's when I told Maruchan, hey, we should probably look at this variance process here.
And I know it took 2 weeks, besides because they had to go back to corporate.
Yes, that was it. We originally contacted Maruchan, talked to them about the variance. Having never been familiar with the process, it took some time to explain the process and what it was all about, how it could benefit Maruchan. And after they understood that, they took that back to their management in Japan, and it took some time for them to understand as well. And then ultimately the order came back to draft it. Actually, the order came back to draft the petition very quickly. It did take a couple of days after that then to go back and forth and refine the petition, of course.
Did you, I see that there's a time sent to like 30th. Was that mailed in or did somebody bring it in?
Yes,
30th
correct.
and delivered it at the clerk?
That's correct.
All right. No further questions. Thank you.
All right, any other questions from members of the board? Thank you, Mr. Jones. Floor is yours, sir.
No argument, Mr.
Okay.
We don't have.
All right, good. So why don't we go ahead and move to closing? On the petitioner side first. On good cause.
Thank you for members of the board for hearing this bifurcated issue of good cause. We believe that Maruchan has acted diligently in filing interim and general petition, and further that the impact to not only Maruchan itself but its employees would greatly outweigh any adverse impact towards the air quality. We believe that this good cause is necessitated by the fact of the history that Maruchan has always passed any of the tests that have been submitted to the AQMD. And since 1978, this has never been an issue. And it's reasonable that the petitioner knew at the time on August 15th, when it was advised by environmental consultants that it should proceed this avenue, that it immediately began to draft the petition. Thank you.
Mr. Jones on closing.
Thank you, Mr. Chair, and thank you members of the board. The position hasn't changed from the argument. We, under this, it's not something they can control. They, as I said before, we're very diligent in responding to our questions with our staff and coming up with various conditions. And in terms of delay, I think it was adequately explained by having to go up to corporate, and they did the best they could in terms of getting a response. And so for those reasons, the board would find good cause. The executive officer would not object.
Thank you. Members of the hearing board on deliberation.
I will support the motion for good cause. I'm reluctant. It seems to me that they did have a failed test and they were simply optimistic it was a mistake. But then they got an NOV from AQMD on May 6th was suggested they didn't think so. I think even if you were inexperienced agency, you kind of take it to someone who knew something about that, like your environmental consultant, to see what that meant, and I just keep waiting. But since the district's not opposed to it, I guess I won't either. But maybe try with another circumstance.
Mr. Balakapalan.
Yeah. I can find because I sort of echo Mr. Pittman's comments too when they were first received the violation, but I think, as I said, they kind of caught by surprise, and so they scheduled a retest right away. So they were waiting for the results of the retest to make final determination whether they're out of compliance or something was amiss with the system, because in the as was provided, they didn't have a history of not complying. I'll leave some other question in the next phase of the hearing, because they did. When I read the petition, they knew there was something wrong with the fryer, and maybe that's why they need the oil mist control. But again, leave that aside now. Let me go to the. We know there is a violation because they're exceeding the permit limit of tonnage per day, and the emissions. There's a emission factor for each of the lines that they're exceeding that, and so the PM emissions are exceeding those stated limits in the permit, so they are in violation. So that's the first one, and then the circumstantial violation. Well, I think they obviously iffy, but I think they knew from December there was a problem, but I can give the benefit of the doubt that they were going to retest it and see if it is continuing to be a problem. So could they have been avoided, and should they filed at that time? They didn't, but I understand the circumstances why they didn't. And then once they knew that they exercised diligence, I agree. I think when they got the results on July 15, they got the consultant and they started the paperwork, and I think it was submitted by the 30th, so that's within 2 weeks. So while we don't have a diligent period, but I think that's pretty given the time for him to prepare the documents and so forth, and Mr. Winchester hand delivered it also, not so I think was diligent trying to get this to. So, and then the last one is there would be an adverse impact. It would hurt production and whatever the economics associated with that. So for all those good reasons, I do believe I can find also good cause to and move on to the next phase of the hearing.
Thank you. Thank you. Any additional deliberation? Okay, is there a motion laid upon the table? Mr. Perman and Mr. Balakapalan, would you care to tender the motion?
Yes, in the matter of Maruchan Inc. case number 6274-1, I move that we find good cause to proceed to the next in the interim in absence of notice to the public based on discussion and ability to make the findings.
Second.
The motion has been properly moved by Mr. Balakapalan and seconded by Dr. Abraham. Any further question or discussion on that motion? Hearing none. Dr. Abraham.
Aye.
Ms. Verdugo Peralta.
A reluctant aye.
Mr. Balakapalan.
Aye.
Mr. Pearman.
Aye.
All the votes in the affirmative, the matter is hereby approved unanimously, and we're moving on to the next phase of the case. But if in fact individuals are so inclined, can we take a 5-minute recess? So we'll go off the record and be back on in 5 minutes. Right, we're back on the record. Okay, I'm going to ask that we move all testimony and comments into this phase if there are no objections. We'll simply include it as a part of this record as well. Okay. Counselor on the petitioner side, opening statements, please.
Thank you. In order to find a variance petition, there's 6 factors that are required. We believe that the petitioner satisfies the 6 requirements. The first one is that the petitioner is in violation of Safety Code 41701. We set forth those requirements in the good cause section of this hearing. But again, to reiterate, the petitioner is or will be in violation of the conditions of both permits, specifically G70103 and permit G70105. Those both being the new fryers used in the production of the Marishon products. The second factor is due to the reasonable control petitioner requiring compliance would result in an arbitrary taking of property. As we talked about in the last good section, this is a fundamental element, and we believe that the petitioner would be substantially impacted both economically within the petitioner itself, but also economic impact to the workforce and also the production of its products and existing contracts. As a result, it would be disproportionately taking of the petitioner's property. Third is closing of taking would be without a corresponding benefit in the reducing air contaminants. Bill from Optrust provided testimony earlier that this ratio and the air contaminants would not outweigh this benefit. Essentially, that the closing of the lines and or the taking of the property would be without a corresponding benefit to reducing the air contaminants. The last 3 requirements can be resolved, or we put forth that the work that we've done in order to come up with the conditional use permits can be satisfied. Petitioners diligently worked with AQMD in order to come up with these conditional variance terms. So the last 3 factors, which one is that the applicant for variance has given consideration to curtailing production of the source and seeking this interim variance in order to ensure that it is in compliance while also reducing its production in order to ensure that it is in compliance. And further, we'll testimony by Jose that reviewed the actual conditional requirements negotiated, and they'll submit to them, and petitioner will submit to them, which satisfies that requirement. The next is during the period of the variance is in effect that applicant will reduce emissions to the maximum extent feasible. This issue goes to the heart of the proposed variance conditions. We've agreed to reduce the production levels to maintain compliance to the maximum extent feasible. The last requirement is during the period of the variance is in effect that the applicant will monitor and otherwise qualify the emission level. By granting this petition today and the conditions that go along with it, reporting would start today. The first reporting requirement would be required a petitioner to the AQMD on August 19th, 1 week from today. In addition, there would be other reporting requirements beginning on September 2nd, as set forth in the conditional permit. So we submit that the petitioner is in compliance, and this board can grant this petition for grant. Thank you.
Thank you, Mr. Jones. Opening.
Thank you, Mr. Chair. Thank you, members of the board. District, in looking at the 6 factors, I think they've made like necessary showing for each. There's a dispute that they're in violation. terms of conditions, even with some of the reservations fairly represented by the board, these are beyond control. The balancing of the corresponding benefit, we don't see, and certainly we don't want to shut them down, which is essentially what you'd have to do if we took our hardest stance. Yeah, we certainly have given curtailing operations as shown in the conditions we've negotiated. They're developing an oil control system. They have extensive report requirements to keep an eye where things will be or could be, and if we have any issues, we have no mind to assess those and head them off for that as a problem. And during the period, they will again monitor. Again, it's all part of the conditions we've negotiated. So, in light of those things, the district would not be opposed to granting relief in this instance.
Thank you. Petitioner, your first witness.
We can submit the testimony for the good cause portion of it. And Jose Vasquez and Bill Winchester can be available for questions the board may have in regards to that.
Okay, no problem. Mr. Jones on cross?
The district has no cross.
Members of the hearing board.
Mr. Chair, I do have some question for both parties probably. Mr. West and Mr. Winchester. Mr. Vasquez, the initial testing showed it PM and VOC. So you're not seeking relief from VOC limits, right?
I believe that's correct, yes.
Okay. You're familiar with the proposed condition?
Yes, I'm familiar with it.
So can we look at that condition number 1? So there's if the condition exceeds the 55,362 pounds per day, which is about 28 tons in Fry E, then the minimum shall be a day. Can you, I know how it was calculated, but can you explain how, or is your consultant that explain how that number came about?
The consultant will be better.
Okay. 1 and 2 then. However, on the expect the construction to be completed no later than July 18, 2026, correct?
Absolutely.
What's the status with the city in getting permits?
So may I kind of go back from the beginning when we submitted to the city and all that? So the company we're working with, Shipping, they designed the system for us, and they tested it. Rather than having an RTO, having an upgraded technology, when we start submitting for permits from the city, we have to go through 2 different groups. One's an architectural group, and the other one is engineering. You want to move to the next. The architectural group basically is more concerned about the aesthetics from the street, what the equipment is going to look like, where's the equipment going to be installed. We were to pass that within a month and a half. When we went to the engineering group, there were delays, lack of a better term, inexperience from the manufacturer of the system working with the city of Irvine. Many requirements, we had to go almost like an inch by inch process. Anyway, where we are right now, we're about a week away from the last portion of the requirements, which are drawings explaining all the electrical on the plant, all the sewage lines on the plant. Very extensive work that was required by the city for an architect to do all the drawings, working with the engineers that design our plant and capturing all of the data that we have. The plant was built in 1973, so it's paper. So that's the last stage we have. Once the city give us the brochure and they're going to give us the permit to move forward, within a week or two, we'll have the mist system on site. And within another week or two, we can start the installation, which should take more than 2 or 3 weeks to put together.
So the condition number 3 says that, you're complete by no later than July 18, 2026. However, I guess we can clarify that in the regular hearing till when, based on construction, but you still have to test it to ensure compliance, right? So the final compliance months away from that, right? Because you have for the reports to come back from the testing company.
Correct. So we're hoping that it is installed in place and tested in the next 3 months. And that's a conservative figure.
Okay. And condition 7, provide incremental support for permitting installation process. That's with the city of Irvine.
Correct.
Yes. I mean, the permitting with the city of Irvine installation process was yes. on that, yeah. And okay. Now, it's on your petition. Why do you have to modify your wastewater treatment? Because of you adding the oil filter?
Modify the wastewater treatment?
Yeah.
Because the location where our regular water treatment system, we're talking about 200 yards away. So we install a new one just for that piece of equipment.
When you flush it to get the oil and stuff to the wastewater?
Yes.
So that's also permit pending, or has it been approved?
No, that's been approved, and I actually have pictures of it. We're in process, and it should be completed within the next week or so.
Okay, so that phase won't hold you up,
yes.
Basically. Okay. Okay. All right. That was my other question for Mr. Winchester.
Ms. Verdugo Peralta. You're on mute. There you go. Floor is yours.
Mr. Chair. The question, and you may have already answered it, and I want to verify the pronunciation of your last name. It's Velasquez. Is that correct, sir?
Sorry.
Pronunciation of your last name.
Is that the correct pronunciation? Velasquez, not Vasquez?
Velasquez.
Okay, all right, just wanted to make sure, because we're breaking up, the audio is breaking up over here. My question for you, and you may have already answered it, like I said, the audio is breaking up. In regards to the city of Irvine and the permitting department, did they give you an estimate of when they would have that completed, or has that already been completed?
An estimate for the approval of the permit?
Correct.
No, they have not. We're still missing some documents that they're requiring and they to the city within a week or so.
Within a week that you're gonna present them to them, or within a week that they've said that they could possibly finalize your permitting?
Could you repeat the question? I'm sorry.
Yes, I'm sorry. I might be breaking up on your side as well. My question was, you mentioned a week. And is it a week that you're going to provide the documents to them, or did they say that they would get it permitted within a week of you presenting the documents?
We are away from presenting the last requirements for the city to approve.
I'm sorry, can you repeat that? You broke up again. Sorry about that.
It will be about it will be about a week from today's date for us to deliver the last requirement that the city put us, which is architectural and engineering drawings when it's installed.
Okay, my concern is, having worked with many cities in the building departments and permitting departments, is they take a long time. And I would advise you to be on top of it as much as possible, even if you're calling them, a couple of times a week, because if you don't, they won't see it as a priority. They'll just do it as an order comes in. So I would strongly suggest that you be in contact with them constantly. And I don't know whether that's you or if that's going to be Montrose.
That's you completely. After the submission day, because we have to submit everything online, I requested formally a meeting with the engineer of the city 2 days after this submission to this. What was submitted, was anything missing? To be quite honest, we are desperate to put this system in place.
Well, I recognize that and I agree with you. However, knowing how slow the cities work, they have so many orders that come in, and especially City of Irvine that does a lot of building still out there, that I'm suggesting to you that you be on top of it and constantly call them. Otherwise, they're not going to see it as a priority as much as you do.
I understand. Thank you.
And my only other comment, again, this is to Montrose, not to you, sir, is that you have got to read that petition a little bit better. 15 and especially 16 actually calls out for a list, a chronological list. And Montrose, we see you more times than most of the other consultants. So I would strongly suggest that you make that part of your future practice.
Will do. Thank you.
Thank you. That's all,
All
Mr.
right,
Chair.
any additional questions from members of the hearing board? All right, Mr. Jones.
The district has no witnesses, but we do have available from compliance and also from engineering if the board has questions.
All right, thank you. Let's move down to closing.
For Mr. Winchester.
Go right ahead, sir.
Yeah. Okay, Mr. Winchester, condition number 1 and 2, can you explain to the board how those numbers came by?
Yes. So basically what happened was there was a test result and the emission factors from that test result for the PM10 were calculated. Based on it, basically there was a calculation, an equivalency calculation, which said at this emission factor, when will we exceed the 1.91 pounds per day, which is equivalent to our normal emissions for that fryer. And so we figured out that at 55,362 pounds of dough per day at the 0.069 pounds per ton of material for fryer E, for example, we would be at that 1.91 pounds per day equivalent. So anything more than that, anything than 55,362 at that emission factor would result in excess emissions. So that is why the condition is crafted in that way. We exceeded that level, because below that level would not be excess. The other thing I'll point out here is that conditions 1 and 2 were not necessarily intended to be limitations on the petitioner, as opposed to just defining what constitutes excess emissions or not.
Okay. It's kind of unusual to see this way. You're not limiting beyond the material, right?
Correct. The permit has the permit limits.
So, one fry E, 28 tons per day, and you're permitted for 95 tons. So that's, but what's the normal, how high do you go during normal operation? Mr. Vasquez would know.
I would have to defer to Mr. Velasquez.
And the reason I'm asking is, one of the conditions is you're trying to minimize emissions, which means you reduce your production. Right, that's one way. The way you craft it, you're not really, you're just saying we will calculate excess based on this throughput limit. You're really sticking a condition saying I will not exceed this throughput limit.
Right. And that may be something that that Mr. Velasquez needs to speak to as well in terms of the potential harm to the business even taking a reviews through during this very period. Obviously, Martin want to do whatever mitigation it could to the extent feasible, but if that means that they're still, going to have a big impact on their business, that is why we credited them in this way with the prosecutor. Is that there weren't technically limits on their ability to produce, but they were a definition of what constitutes excess emissions. So we clearly knew when we had to pay the fee.
Okay. It just somewhat misleading. It's impression that this is a production. Based on production anyway, based on the. Okay. Maybe I'll ask Mr. Velasquez. Sorry, switching to Mr. Velasquez for a second. Fry E has about 90 tons per day. What is the typical rate in Fry E? Do you go up to 95 or do you go?
To the best of my abilities, the only way I could answer is that the way the production is set up to meet the standards of the permit. We use the calculations made by our consultants to adjust to those levels. But from a technical standpoint, in this math, I couldn't answer your question in precise numbers.
What I'm trying to get at is, I think your attorney made an argument that you emissions. So during when one way is to limit your production, and so I think Mr. Winchester was saying that might be affect your business. So I'm trying to get a sense of what kind of mitigation you take to as a mitigation.
The easiest thing for us would be to reduce our production, is to meet standards, be in compliance. On our stacks or the other equipment that is on the roof, we have some potential value in looking at it and see what changes we can make. But to answer your question, as far as numbers are concerned,
Okay, let me rephrase it another way.
Okay.
If you were limited to this production level of so many pounds per day, would that affect your production to 28 tons per day? Would that have an impact on your production?
If it is below the limits on how it will have a significant impact.
So basically, you're not really looking at mitigation during this period. You want to go with business as usual during the period, in a nutshell, basically.
That will be accurate.
All right. Okay. All right, I understand. Okay.
Thank you, Mr. Jones. Did you have any further comments? And if not, then we'll move to closing.
No further comments from the district.
Thank you. On the petitioner side, let's move to closing.
Thank you, Chairman, members of the board. We believe that the facts that we've outlaid and within the petition of the testimony find that there's good cause to grant this interim variance petition. We feel like we have provided evidence that have sufficiently met the factors in the 6 requirements. The petitioner has also reasonably and diligently worked with the prosecutor and to come up and craft these proposed conditions that will support during this interim variance period. So based on the testimony and the petition, we respectfully request that you grant the petition.
Thank you, Mr. Jones. Closing arguments.
Well, I think I've made these as far in light of where we are today and the time. I'll just reincorporate at each of the factors and the manner of their cooperation, the way that we do resolution with respect to the conditions. Based on that, the district would not oppose a grant of relief in this instance.
Thank you. Members of the hearing board on deliberation.
I'll go ahead and start. I mean, since this is an interim and they're scheduled to come back in September 9th, I think, back for a regular variance, so maybe we'll get some more information, rates and so forth, you know, because Section 1 and 2 is misleading in a sense, because they're not really limiting a production. No, they do want a limited production, you know, so I but you know, I'm not going to. It doesn't help because no matter what, you got to calculate daily emissions. You know, whether it's above or below. You know, and you will know whether there's excess emission, and this will just trigger. So I don't want the board. I know get the impression that they are limiting you to this production level. We are not. You're going to do production as you do. However, I think when you come for the regular variance, Mr. Vasquez, if you have some production data that shows that maybe you're not really doing 95 tons per day, you know, maybe whatever the amount is, which shows some mitigation there. Okay, so that so we have some before we give the regular variance, which is for a longer period of time. And the other thing I was also going to say that during when you come back regular, and I think you may have a better idea on the permitting and so forth, when it's the final compliance date, taking into account the construction. It should be completed July 18, and then you got to factor in the source tests and the reports. You know, so and then if you go beyond a year, then you do progress and so forth from this date. So, but we can defer that to the you know, to the regular variance. We'll get a little bit more information. This is the interim measure. So, I do. I can make the 6 weeks for granting the interim variance. You know, petitioner, as you know, is a violation of the permit condition for that under reasonable control. It would be unreasonable by this stage. We'll see a little further that the harm to petitioner clearly is a benefit, you know, to the emission associated with this 2 fryers. There's about I think calculate about the difference. The high production at the top production level and what the testing and you allowed. So it's about 7 pounds per day. So when we see the data in next month, when you got the regular variance, we'll get a better idea if you're there or not, you know. So whether you've given curtailment, you've given consideration, well, we can say you have given consideration, but we, at this point, I don't think you are curtailing operation, but you calculate excess emission as required, you know, because you have the emission factor and you also back out when you would exceed the daily allowed limit. But you know, it's not a mitigation you're proposing, but we will have to, you know, at least I will see, you know, based on your July next month, whether we need to pose some kind of mitigation of production based on your schedule and so forth. So other than that, so I can make the 6 findings necessary to grant the interim variance until we have the regular variance.
Okay, is there a motion?
I just want to say I concur. I think while there might be some defects in the form, since it's interim, we can have them corrected, or they might consider some of the comments and bring revised to us at the final hearing in September.
All right. Does anyone want to lay a motion on the table?
I'll go ahead and make a motion, Chair. So in the matter of Inc., case number 6274-1, I move that we grant interim variance commencing today and continuing through 2025, pending in 90 days or until the notice is scheduled for September 9, 2025, whichever occurs first from, one thing I forgot to ask, but I'm going to go ahead and rule for 3B, F1 and permit condition 193.1 and 190, yeah, I'm sorry, permit condition E 193.1 and permit condition E 193.2. However, not grant, including that was included the petition because it was a petition, and I didn't see the back permits listed anyway. So, so from those petitions, and I'm not including, as listed in the petition, I'm not including the back 1303A. So for the equipment permitted as G70 103 and 705 that's the device ID. They also have a permit number. So we can use one. So device D44 and device D45 for E and F respectively, located at 1902 Deer Avenue in Irvine, California 92606. The access solution will be approximately worst case 7 pounds per day. And the conditions will be set for the exhibit A. The proposed condition is set for the exhibit A. No changes.
Is there a second?
Second.
So moved by Mr. Balakapalan, second by Ms. Verdugo Peralta. Any further question or discussion on the motion? Hearing none. Dr. Abraham, your vote.
Aye.
Ms. Verdugo Peralta,
Aye.
Mr. Balakapalan,
Aye.
Mr. Pearman,
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. We thank all of you for your time this morning. I look forward to seeing you. The regular is set for what day is that? Is that September 19th?
9th.
You know what? The microphones broke up. We said September 9th, correct?
That is correct.
Okay, perfect. All right, we're adjourned at 10:55 a.m. and off the record.
Mr. Chair, I had,
Oh, I'm sorry. I do apologize. We're still on the record. Ms. Verdugo Peralta.
thank you. I am also very concerned in regards to the comments by the mayor from El Segundo. I understand that there was a letter on July 9th that was sent to the board. However, I did not receive it, and I'm not faulting staff. Up here, sometimes I don't get everything until later, or if at all sometimes. So I'm assuming that that was the glitch there, because I would have said something, and I believe our hearing was originally in November, or it was supposed to expire in December, and I had asked that it be extended until August. And I'm very disappointed that the district missed that date and that opportunity to bring it back before the board, because of the fact of, in the interim, there's been 341 odor complaints and 12 NOVs. So that to me is also unconscionable. This particular organization has not listened to any of the other agencies that have been on them in regards to the health effects and danger to the public and their own employees. So I don't know at what point we can do anything, or do we have to wait for legal to do something? And I so miss Mr. Haynes as well. He is a wonderful inspector. I don't know whether he retired or was just taken off the case, but those are my comments in regards to Hyperion. Thank you, Mr. Chair.
Thank you very kindly. We will adjourn at 10:58 a.m. and we're off the record.
Thank you. Have a nice weekend, everybody.
And you too.